For more on this, we're joined by the founding director of the Kara Heritage Institute, Dr Mathole Motshekga. Good morning. Welcome to Newzroom Afrika.
Good morning, Motshekga and the listeners.
Firstly, Dr Mathole, before we lunge into this conversation, a very important conversation, what are your thoughts on Manelisi Mampane being granted bail, especially after what's been described as very dubious circumstances?
That is a reflection of the legitimacy crisis into which our legal system is descending. And it is a reflection of what we are hearing from the clip now, that there's an emerging rebellion against our judicial system, because it has not been deliberately transformed. It is administered in foreign languages, Afrikaans and English. The indigenous people, the indigenous languages are not taken into account. So what we should call the spirit of the law may be different from the indigenous people and from our judges who are rooted in the foreign Roman Dutch law and English common law, and not in the indigenous African laws.
So essentially, a Roman Dutch law is failing, as we've just seen in the clip of a very angry King Dalindyebo saying that this judgment was violent and that he has every intention of handling this matter through customary law, because in his own words as well, Roman Dutch law is failing. Does the king have the power to overturn the judge's decision?
Before we get to that, I think we must say that the Constitution of the Republic of South Africa, Act 108 of 1996, enjoins the democratic state to address the injustice of the past and build a society based on social justice and human rights. And the question is, have we identified those injustices of the past? Have we addressed those injustices of the past? Do we have the platforms to address them and to develop a program of action to address them? The answer is no. For instance, the stolen land that must be returned, the stolen land and natural resources, which must be restored to the victims, must be bought by the state from the fiscus. The money that must go to social services and development must buy the land. How do you struggle for 100 years to get what was stolen from you? When you get it, they say you can't receive it unless you pay for it. And then you have land and native administration policies established by the British in the 19th century. They have been carried over into the apartheid state and carried over into the democratic state. Our culture, religion are not recognized. And that's why those who know say that the African majority have been reduced to a cultural minority. So what the king is saying, he has no right to do, but it is important because it awakens us to the fact that there is something that we have not done right, namely in addressing the legacy of the inhuman British and apartheid colonialism. So I think that we should not condemn him. We must condemn ourselves for failing to adhere to the Constitution of the Republic.
So how far does the king's powers extend? And I'd like to, for you to expand on saying that we must fail ourselves. Is it the Constitution that should be taking accountability for not really implementing customary law? Is it the kings that should take responsibility for not implementing customary law? How far do their powers extend? For instance, can the king summon Manelisi Mampane? And if he's found guilty, can he convict him and sentence him?
He cannot. But the issue here is the Constitution grants equal status to Roman Dutch law, English common law, and indigenous African laws. But in practice, how do you expect the judges who only know English common law and Roman Dutch law to grant equal status to indigenous African laws? So there is a failure to implement what the Constitution is saying. And the lawyers, as lawyers, we are also taught something called the doctrine of repugnancy, which means that where indigenous African law is at variance with Roman Dutch law and English law, the other two must prevail. In a country which is an African country at the southern tip of the continent, we are ruled by European laws. Now, this ancestral spirits of our people are beginning to rebel against this type of order. So maybe the lesson that we can take there is that we say we have the best constitution in the world, but in the eyes of our people, that is not the best constitution. So the transformation is lacking and must be addressed before the whole constitutional order runs into an illegitimacy crisis.
All right. So, Doctor, don't you think that the problem is perhaps that there is some kind of conflict of interest? Because how is there customary law and still we have to adhere to Roman Dutch law? And when is customary law applicable and when is it not?
The Constitution enjoins us to develop and mainstream so-called customary law, but we have not done so. And as a result, there is a clash of legal cultures that we are facing now.
Now, could you take us through, maybe for even the understanding of our viewers, Doctor, exactly how customary law processes worked then and how they work now? We can use a case such as this, the case of Manelisi.
You know, the question is that the law has got to demarcate areas of application. For instance, the law that I know says that serious cases like rape, murder, fall within the jurisdiction of the modern courts, and minor offenses should fall under the jurisdiction of the tribal courts, which means that indigenous African laws are subordinated entirely to the European systems because we have not consciously addressed these jurisdictions and developed the African customary law so that it becomes equal to other laws as the Constitution enjoins us. So it means that we are a cultural minority, even in the legal system, and there are no signs that we are about to address these disparities. And as a result, people will begin, as the king is saying, that they will ignore this and then apply their own laws, which means that we are going back to the law of the jungle because of our failure as the democratic state to address injustices of the past.
All right. In closing, Doctor, King Dalindyebo did say that he is the court of first instance in his land, which would seem very practical from where I'm sitting. But in light of everything you've just explained to us, is this true or not?
No, it's true in the sense that, if a criminal commits an offense and runs into my house, when the police come, they must talk to me as the head of the house first to say, no, there is a suspect in your house or on your premises. And now, because our kings and queens are young people who have not been educated even in their own customary system, you can't blame them if they don't know where their power starts and ends. So this is a question of education. And for instance, instead of providing civic education, our households are bombarded with Moja Love and those things. You don't know what the purpose of Moja Love is. We could have a dedicated slots like that of Moja Love to educate the people about their history, their culture, their values, and so on, so that when they go into the public, they know how to conduct themselves. Our kids now are in a crisis. They don't know who they are. What is it that they should follow? Mojalav or what? And what is Mojalav depicting? A degenerate society, and our kids cannot even have self-respect, self-image, because they see themselves through the eyes of Mojalav.